This is the Palace of Justice in Nuremberg, Germany. Many around the world may not know of its significance, much less those in nations in turmoil. But it is here that the concept of international criminal justice was put into practice. After the Second World War, the Allied forces held the International Military Tribunal and 12 subsequent American-led trials to try German military and civilian figures who were complicit in crimes that surpassed any threshold that had previously been set. Theirs were international crimes, the crime against humanity, the crime against peace, the crime of conspiracy, and war crimes. Justice, most proponents of this court will say, was served in the years of the Nuremberg Trials. But it is from here that the concept behind the formation of the International Criminal Court found precedent.
What was really the big breakthrough in Nuremberg was that the conviction arose that to end conflicts and to have sustainable peace, we need justice carried out by a judicial body of law, i.e. by the respect for the rule of law. So I would say this is really, in a nutshell, the big accomplishment of the Nuremberg Trials.
The concept of international criminal justice is one that has been variously described as controversial, subjective, as a sign of modernity and progress in dealing with international crimes. But one thing is for certain, the concept of international criminal justice is evolving.
Law, not war.
It's been 10 years since the July 2002 ratification by 60 states of the Rome Statute. The International Criminal Court now faces some of the most blatant abuses of international criminal law. For example, the atrocities being committed in parts of the Democratic Republic of the Congo, as well as others committed in the geographical territory of states parties that it is either reviewing, is seeing through trial stage, or in the case of the March 14th Thomas Lemanga trial, its first ruling has completed. But what impact have the Nuremberg trials had on the future of the ICC with respect to its mandate? 4 words introduce a key aspect of the ICC's future: the crime of aggression. Originally, during the Nuremberg trials, this same crime was called the crime against peace. That is, where a state, on the initiative of its leadership of that state, goes to war against another state. A number of people were convicted of this particular crime, and it was thought the world had heralded the entry into force of a crime that could prevent war. Ben Ferencz, a noted scholar on the subject of international criminal justice, perhaps has more understanding than most on the subject of the change from war to peace, and the abandonment of war as a means of diplomacy. Over 60 years ago, Ferencz was the chief prosecutor in one of the 12 American-led trials of people suspected to have committed one or more of the acts stipulated as crimes that could be brought before this court, including the crime against peace. Over 60 years later, Ferencz stood in the famous courtroom 600, this time not for a cross-examination of the suspect, but more for a re-examination of this concept, all these years after the Nuremberg trials.
We have all been raised, including me, with what I call the war ethic. You glorify war. You get medals, the band marches, the flags are flying, everybody is stirred, and it's great. Even some of the most fundamental approaches can be changed. There's no reason to glorify war. War is hell. So we have to move away from the glorification that war is great, and to another one, that peace is great. And the UN Charter requires that. They list 10 other ways of settling disputes. Judicial settlement is one of them. Now, sometimes you'll lose the case. Judges vote 5-4 in the US Supreme Court, for example. 2 years later, they reverse it. It's 4 to 5 the other way around. But even if you lose a case, it's going to be better than war. The logo on my website is law, not war, because I think law under all circumstances is better than war.
Moving forward, though, the international community's new attempt at creating and improving on the sort of justice seen at Nuremberg has faced all sorts of challenges. From the length of time it took for a large part of the international community to come to the table and hammer out the Rome Statute to the now more pertinent questions, for instance, whether heads of state immunity or senior government official immunity can apply in an international system where states parties have submitted to the Rome Statute, which does not recognize immunity.
There are two types of immunities that international law recognizes, and actually the Rome Statute mirrors this very clearly in Article 27.1 and 27.2. One type is the official capacity defense, which is what is in the Nuremberg Principles and what is in these General Assembly resolutions. But that's not the same as head of state immunity. And we know that because the Rome Statute has Article 27.1 and Article 27.2, which is the immunity that we're talking about. So it's not, if it was sufficient just to have this official capacity does not exclude from criminal responsibility, the Rome Statute would not have stopped in Article 27.1. In those cases where we're dealing with the head of a state party to the ICC statute, then the effect of those provisions, particularly Article 27, is to remove the immunities of heads of states, of states parties.
This particular subject, as well as others, have combined to create yet more challenges to the court. Critics of the Nuremberg trials have often said that winner's justice was exercised with respect to the Germans on trial. The modern-day version of this is the ICC's alleged pursuit of weaker states in the international scheme of geopolitical power, states in Africa being the biggest drivers of this. The ICC's new prosecutor, Fatou Bensouda, as well as a panel during this conference, dealt at length with this question.
Africa has been coming towards the ICC. Africa, from the time it was to be established, I don't need to repeat what happened. There are many people in this room today who know what happened and the role that Africa has played in making sure that the ICC was established. The first cases of the ICC were referrals from Africa. Africa requested ICC's intervention. In fact, this idea of Africa, ICC targeting Africa, I think was completely demystified again when Mali, as recent as July of this year, requested again the ICC's intervention.
I think it's in the interest of justice, and I think it's in the interest of the reputation of the ICC that the court stretch its work beyond Africa. By doing so, I think the court is going to deny powerful African tyrants the stick with which they so easily and distractingly wave at the ICC. And I think it will also, obviously where the evidence shows a need for the court's intervention, be a means by which to pay homage to the plaque in the United States Supreme Court that we spoke about yesterday, being a plaque which speaks to equal justice under law. So there's a potential, finally, for a win-win situation. For the ICC to do justice as it should continue to do for the African victims of the cases that are already rightly before it, and to do justice to the victims of such crimes outside of Africa who equally deserve the court's and the international community's attention.
Just some context about the genesis of this idea of establishing an international criminal jurisdiction for an African regional court. I think we need to understand some of the dynamics behind this, because it is a common assumption now to say that Africa is doing this simply as a reaction to the indictment of al-Bashir, which is totally wrong. It misreads the history of the continent and the history of the African Regional Organization. Discussions about the possibility of establishing an international criminal court in Africa or competence to try international crimes for the African Court of Human and People's Rights predate the indictment of Bashir.
The United States of America, a key player in the International Military Tribunal and the 12 other trials that took place at Nuremberg from 1945, unfortunately is always the elephant in the room whenever it comes to the question of doublespeak about the independence of the court. From its role in the United Nations Security Council referrals, one of the triggering mechanisms for the prosecutor of the International Criminal Court's decision to investigate whether the crimes under the jurisdiction of the court, to its refusal to sign the one document that could rid it of some of the accusations of playing to a double standard.
The United States was perhaps the most vocal supporter of an international criminal court from the late 1940s up until this century, and continues to be. The problem was that the original draft statute had a mechanism for triggering cases, what they now call the triggering mechanism, or a jurisdictional regime, that was more heavily dependent on the UN Security Council.
However, recognition was made at the conference of the more progressive approach by the United States to the International Criminal Court. Still, though, the United States' current position came under scrutiny often during this conference. The International Criminal Court, though, is not the only instrument of international criminal justice that came after the Nuremberg Trials. Conflicts still plagued various continents, in the former Yugoslavia, in Rwanda, and in Sierra Leone. Devastating conflicts in which the worst atrocities the world had seen since the Holocaust that in part created the need for the Nuremberg Trials, necessitated the creation of ad hoc international courts that had jurisdiction over these crimes. These courts are now concluding their work, and all of them have had measured success in bringing to book those most responsible for the slaughter of millions. Serge Bramets from the International Criminal Tribunal for the former Yugoslavia, Hassan Boubacar Jallo, the prosecutor of the International Criminal Tribunal for Rwanda, and Brenda Hollis, the prosecutor from the International Tribunal for Sierra Leone, all offered their experiences as prosecutors at the helm of these important instruments of justice, and how those tribunals can be learning points for the ICC in the future.
The arrests of the 83 accused who have now been brought to trial. From a best practices point of view, we've tried to explain the challenges we faced in each of these arrests and how they were overcome. Given that the international system, perhaps with the exception of the Lebanon Tribunal, does not get triggered until you arrest somebody. In other words, you cannot have a trial in absentia. It's very important to make sure that you have a proper arrest strategy.
The success or the failure of ICTY will also very much depend on how the countries of former Yugoslavia, especially Bosnia, will be able to deal with the remaining 700-800 cases for the years to come. And then, of course, legacy. The three of us, together with the colleague from the Cambodia Tribunal, we are working already for some time on a kind of best practice manual, where we are also very, very honest about where things went perhaps not so well. We all agree that putting an investigative team together has been different in the early days of the tribunals, and we would it probably too different today.
In the process of achieving our objective, our mandate as a criminal court, we've also added to jurisprudence. We were the first court to indict, prosecute, and then render judgment against individuals for the use, recruitment, or enlistment of child soldiers, for attacks against peacekeepers, and we have also helped to develop the law on sexual violence by refining the law and adding to the law of sexual slavery, and finding that forced marriage is an other inhumane act.
Learning was a big part of the conference, not just in the courtroom 600, but for a special group of attendees who are crucial to building a better understanding of the ICC and all the issues surrounding it. The Wayamo Communications Foundation, with the help of the German Federal Foreign Office, flew 15 senior journalists from across Africa and the Middle East to Nuremberg for the conference, and a media workshop on the subject of the International Criminal Court. Among those who spoke during the workshop are Christian Wienerwieser, the former president of the Assembly of States Parties and current permanent representative to the United Nations from Liechtenstein, who spoke on the question of the crime of aggression, what was called the crime against peace during the Nuremberg Trials. Philipp Ambach, the special assistant to the president of the International Criminal Court, also spoke at the workshop, as well as Janet Anderson from the Institute of War and Peace Reporting, as well as a retinue of panelists from the conference whose participation was well received by the journalists.
I do believe that I got well informed about the ICC and the principles of the ICC and the implementations of the principles of the ICC worldwide.
There are a lot of mistakes that we make as journalists in situation countries in terms of oversimplifying things or underreporting the context of the cases that our countrymen are facing, and this helped to sort of give us an understanding of how to do that.
There were a lot of new issues around court reporting procedures, which I feel is very important if the media has to report adequately and efficiently on criminal justice proceedings. Because bear in mind that criminal justice reporting brings an added responsibility. It's not like civil proceedings.
So where will the ICC go next? And how does looking back through the lens of Nuremberg inform the direction that the ICC will take? These are questions with no certain answer for now, but the hope for the ICC, one that resonated with those at this conference, is that the ICC will stand as a beacon of the international community's success in creating a force for good, one that prosecutes those who would try and take the world back before Nuremberg, to a time when war criminals went unpunished.
We have to begin to turn around this deeply ingrained, glorious war ethic and paint it for what it really is.